Did you know that during the early years of the United States, the Supreme Court was on the brink of collapse? Today, the Supreme Court plays a crucial and independent role in our government. It's the branch of the government that interprets the Constitution, telling people what the Constitution means and how it applies to our daily lives and in different situations. It has a mighty checks and balances power against the President and Congress, striking down any laws or actions from those two branches of the government that the justices feel go against the Constitution. But this wasn't always the case. The Supreme Court didn't always have as much power as it does today. And that's what we're going to dive into in today's video. In today's video, we're going to dive into the Supreme Court's clumsy early years, how it almost collapsed, how it came under siege, and finally, how Marbury versus Madison became a key turning point because of one man's masterful stroke of political genius. Okay, so we're going to dive into the years from about 1788 when the Constitution came into effect and up to about 1803. And these are a few things we need to know before we really get into things. First, during this time, there were two political parties in the United States. We have the Federalists on one side, and that's under George Washington and President John Adams, also led by Alexander Hamilton. And this party wanted to really have a strong central government that would unify all of the states together. On the other side, we have Thomas Jefferson's Democratic Republicans, and his right-hand man was James Madison. And they felt that what George Washington, John Adams, Alexander Hamilton had done to the federal government was too much and had made it too big and taken too much power away from the states. So their goal, the Democratic Republicans' goal, is to make the federal government less strong, and they come into power in the 1800s after the Federalists. In this video, I will be calling Thomas Jefferson's Democratic Republicans as Republicans. That's what they were called back then as well. However, I don't want us to confuse Thomas Jefferson's Democratic Republicans with the Republicans of today. They're actually two very different parties. The Republican Party of today came from Abraham Lincoln's Republican Party. That's when it was born, during the Civil War years and a little before that. But today's Democrat Party is actually the party that can trace their lineage all the way back to Thomas Jefferson. Also, don't forget the Constitution creates three branches in the federal government to check and balance one another. The first branch is the legislative branch, which is made up of Congress, right? The House and the Senate. The second branch is the executive branch, and that's the president to enforce the laws. And finally, the third branch is the judicial branch. And in the Constitution, the framers didn't say too much about it. It's the branch of government that has actually developed more and more as the years have gone by. For example, because the Constitution was kind of big on the judiciary branch, the first Congress, right? The first group of people that came into power in Congress created the Judiciary Act of 1789. This act established the Supreme Court as written in the Constitution, and George Washington assigned those first justices. It also did a few other things, and we'll dive more into that when we get into the Marbury versus Madison part of the video. And in the judiciary branch, we also have three levels of courts. Okay, three levels in our federal court system. The lowest level are called the district courts, okay, and that's the most numerous. The second level is called the circuit courts or court of appeals. And finally, the highest court in the land is the Supreme Court, which is what we'll really get into today. Okay, so now let's dive into the early years of the Supreme Court after they were established. So as I've said before, in the early years of the United States, the role and power of the Supreme Court were far from the established pillars that we have today. Initially, both Congress, the states, and even the president claimed that they also had the authority to interpret the Constitution, meaning to say what the Constitution means. And in fact, many of the founding fathers, most prominently James Madison, the man known as the father of the Constitution, actually believed to his dying day that all three branches of the federal government had the power to tell the people what the Constitution means and how it should apply to daily life and to all other laws. It was just really hard for people to accept that judges alone would have the sole authority to tell everybody else what the Constitution actually means. After all, what this would do is to have these unelected officials have the authority to strike down the laws of elected legislatures, elected lawmakers. And that just seems to run against the face of a democratic institution. So in these early years, the public really saw the Supreme Court as aristocratic and way too out of touch, which I actually explain in the video that's linked above. So in addition to really bad public perception, the court itself functioned really poorly. Judges in the Supreme Court frequently resigned, and it was really hard to find people to replace them. Between 1789 and 1801, there was a revolving door of justices. 12 judges served, and 5 of them, including 2 chief justices, resigned. The judges also really struggled to gather a quorum, meaning they struggled with finding a decision that they could all agree on. So as a result, this made cases a whole lot longer than they needed to be, and in some instances, cases were canceled. So it's no surprise then that the morale among the Supreme Court justices was very low. And John Jay, in his refusal to return as Supreme Court Chief Justice, said that this Supreme Court just really lacked the energy, weight, and dignity that it needed. But despite all this, the Supreme Court from 1789 to 1801 was actually really successful in expanding the federal government's power. Remember, during this time, the Federalists were in charge. The Federalist George Washington was president, and there was a Federalist majority in Congress, and the bench was full of Federalist judges. So the whole goal of the federal government was to expand its power. From 1789 to 1801, the Supreme Court only heard 63 cases. In those 63 cases, they were successful in establishing their authority and superiority over the state courts. In addition, they also said that the Supreme Court had the authority to try criminal common law. Remember, common law is that set of laws that's tradition and is not necessarily written down, versus statutory law or statutes, which are those laws that are written down. Again, more about that in the video linked above. During this time, the Supreme Court also expanded the definition of treason so they would have more power to prosecute people who they deemed as a threat. Remember that Alien and Sedition Act? They also further diminished the power of the state courts by saying that, hey, state courts have no right to take away people's vested rights or the vested rights of the federal courts. Before we continue, if you're finding this video helpful so far, please don't forget to hit like and subscribe. This will help this video reach other people who could also use it. Unfortunately for the Federalists, they lost power in the election of 1800. John Adams lost his re-election bid for the presidency, and Thomas Jefferson became the president of the United States. In addition, the Federalist majority in Congress was replaced by Republicans. So now you have 2 of the 3 branches of the government controlled by Republicans, and the Republicans would certainly love to have control of the courts, but the one thing that's in the Constitution is actually the removal of judges. So the Republicans couldn't just remove the Federalist judges sitting on the federal courts just because they felt like it. So instead, the Republican Party plotted to really minimize the power of the Supreme Court. some extremes led by people like Virginia Congressman William Branch Giles wanted to just completely overhaul it or even get rid of it. However, many Republicans did see the necessity of the Supreme Court. They just wanted to limit a lot of its powers and make it more accountable to the people. So as soon as they were empowered, the Republicans acted swiftly. Rewinding a little bit, so after the election of 1800, when the Republicans were voted into power, but before they could officially take on the role, Congress was filled with lame duck Federalists, meaning Federalists that were on their way out, that were booted out, right? And so as a last-ditch effort to keep their control of the government, the lame duck Federalists passed something called the Judiciary Act of 1801. And what this Judiciary Act did was to establish even more federal courts, and so that they could put even more Federalist judges in charge. And so, when the newly elected Republicans officially took control of Congress, they immediately repealed the Judiciary Act of 1801, which basically got rid of all those new courts and all those new judges. And the Federalists were actually in uproar about this because they're saying, hey, that's unconstitutional. You just removed a federal judge outside of the process that the Constitution laid out. However, this did not stop the Republicans. Instead, they passed their own Judiciary Act, the Judiciary Act of 1802, which established their own version of the courts, and they filled these new courts with Republican judges this time. In addition, they changed the Supreme Court schedule. And before the Judiciary Act of 1802, the Supreme Court met twice a year for 2 weeks each time. During the rest of the year, the Supreme Court judges would travel around the country and hear cases in the circuit courts. Well, when the Republicans came into power, they said that, hey, the Supreme Court now only meets one time for 4 weeks. Okay, it seems like maybe it's not a big deal because it's still the same amount of time, but what this basically did was suspend the Supreme Court for about 14 months. Their last meeting was in December 1801, and after this change in schedule, they couldn't meet again until February of 1803. In addition, the Republicans also had ambitions to amend the Constitution itself. They wanted to make it so that the president could easily remove any judge that he wanted. All he had to do was address a joint session of Congress, meaning both the House of Representatives and the Senate, and then after a majority vote, be able to remove a judge rather than go through the whole impeachment process that's laid out originally in the Constitution. So the Republicans were determined on removing the existing Federalist judges. For a while, they focused on removing federal judges by using the Constitution's impeachment process for high crimes and misdemeanor. And their first target was a federal district court judge from New Hampshire named John Pickering. Now, you may or may not know, back then it was actually common for judges to be really partisan when they were hearing cases and in the way that they instructed the jury. Well, John Pickering was very, very extremely partisan in how he ran his cases. In addition, he was known for being an alcoholic. And because of this, Republicans were very successful in having him removed, even though he actually didn't commit any constitutional crime or offense. The next target went straight to the Supreme Court, and the Republicans targeted a very partisan Supreme Court justice named Samuel Chase. He's actually the only Supreme Court justice ever in history to be impeached. So the removal process for a federal official goes like this. First, the U.S. House of Representatives meet and they vote to impeach an official, to impeach a Supreme Court justice, in this case, Samuel Chase. And what that basically means is that they're going to go ahead and put Samuel Chase on trial, where the Senate would act as jury and the Senate would then vote whether this justice or this federal official would be removed. And so the Republican House was successful in impeaching Justice Samuel Chase. They accused him of criminal behavior and procedural mistakes in his cases. And this actually shook a lot of people. Many people feared that Chief Justice John Marshall, the Chief Justice of the Supreme Court at the time, would be next. However, the Senate failed to secure the necessary 2/3 vote to actually remove Samuel Chase from the Supreme Court bench. Many Republicans were aware that they would be hypocrites for convicting Samuel Chase of offenses that weren't actually against the Constitution. And again, they also acknowledged that being partisan as a judge is a long-held tradition, even though in Samuel Chase's case, it was really extreme. So they chose not to convict him and remove him from office. However, this acquittal actually led to a change in behavior by Samuel Chase. Ever since then, all the way up to his death in 1811, he decided to stop getting involved in political intrigue and controversy during his cases. So, with the Supreme Court under heavy attack from Republicans during its early years, on top of not being able to function properly, how on earth did it survive? Well, enter we have the savior of the day, the one and only Thomas Jefferson's cousin, John Marshall. But who is John Marshall, and how did he single-handedly fend off the Republican Party? Well, let's dive into his background first. John Marshall, just like his cousin Thomas Jefferson, was born into a prominent family, and his roots were deeply entrenched in the rich and distinguished lineage of rich landowners in the South. However, unlike Thomas Jefferson, John Marshall really stayed down to earth. He was hardworking, he was easygoing, he was unassuming in his nature, and he had a very good sense of humor. Just like many of the judges back then, Marshall actually didn't have any formal legal training. Instead, he gained a lot of his knowledge from his voracious appetite of literature and the classics. He gained an extensive knowledge of common law from all of his reading. In addition, he was just naturally smart and talented. He had a really deep analytical mind. He's able to take complex subjects and break them down into their parts and essence. Jefferson was actually noted saying once about John Marshall, and I'm going to oversimplify it. He said that when I'm talking to John, I never admit to anything, because if you admit to any position to be good, no matter how unrelated to the conclusion he wants to establish, you're gone. So great is his sophistry, you must never tell him yes, or you will be forced to grant his conclusion. Why? If he were to ask me whether it were daylight or not, I'd reply, "Sir, I don't know. I can't tell." So that just goes to say that Jefferson knew to just keep his mouth shut when he was around John Marshall. Marshall's character was also forged in the crucible of the American Revolution. He was captain and actually endured that long winter in Valley Forge, which helped him gain an undying loyalty and admiration for General George Washington. In addition, his involvement in this war really helped him to see the necessity for the states to become united, to become one. In contrast, he viewed Jefferson, who avoided fighting in the American Revolution, as a coward and a slacker. And fun fact, actually, the two greatly disliked each other so much that when Thomas Jefferson was inaugurated, John Marshall had just become the Chief Justice of the Supreme Court and had to be the one to swear him in. Well, he disliked Thomas Jefferson so much that he had his back to him while he was swearing him in as president. So after the American Revolution, John Marshall went back to Virginia and established a prominent legal career. And during the Articles of Confederation and before the Constitution was ratified, so when the state governments had great power, John Marshall actually served as a state lawmaker for the state of Virginia. And in 1788, he participated in Virginia's ratification process of the Constitution. So he became very dedicated to the Constitution and its causes. So despite all this, John Marshall was actually very reluctant in officially entering national politics. He had a very lucrative job. He had a very lucrative legal career in Virginia. So when John Adams approached him to become one of the envoys to France during that whole XYZ affair mess, he had to think about it. And that paved the way to him serving as John Adams' Secretary of State And eventually, John Adams would appoint him as the Chief Justice of the Supreme Court right before John Adams left office. Now, even though John Marshall was a Federalist, he was a moderate Federalist, just like John Adams. In fact, there were many Federalists, people from his own party, who objected to his assignment as Supreme Court Justice. They felt that he would just cave to the pressures of the Republicans. After all, he had opposed the Alien and Sedition Act, and he did not agree with Samuel Chase's very politically biased behavior as a Justice of the Supreme Court. However, he was also very afraid of something called the excesses of democracy, and he wanted to protect the Supreme Court from the attack of the Republicans. It was actually under his leadership that the Supreme Court laid the foundations for judicial review, and he was able to separate the judicial branch from the whims of politics and popular legislative power. Now let's dive into some of the things he actually did to accomplish this goal, specifically Marbury versus Madison. One of the major things John Marshall changed about the Supreme Court was the way they handed down their rulings. So before John Marshall was the Chief Justice, judges would often hand down their rulings individually, and each justice would write their own opinion. But under Chief Justice John Marshall, he really convinced the judges to come together and discuss, and he would even say, hey, let's just drink wine over this. There used to be a rule where they'd only drink wine if it was raining, but under John Marshall, he would just say, well, this is such a vast country, I'm sure it's raining somewhere. If we can't agree on something, let's sit down and drink some wine and talk about it. So where other chief justices would have tried to strong arm their associate justices, John Marshall really tried to promote a very friendly and collegial environment of respect among the different associate justices. At the beginning of his term, from 1801 to 1805, the Supreme Court handed down 46 written decisions, and all of them were unanimous. And John Marshall played a pivotal role in all this. He participated in 42 of the 46 and wrote the court's opinion in each of those. And even after 1810, when the Republicans were finally successful in replacing Federalist judges who retired with Republicans, so in 1810, the Supreme Court was actually made up of more Republican judges than Federalist judges. But even then, John Marshall still had a great leadership style and promoted collaboration and friendliness and respect among the different justices. In addition to improving the way the court functioned, John Marshall also worked very hard to shed the Supreme Court's reputation as an aristocratic institution that was out of touch with the people. For example, he asked the judges to start wearing just a regular black robe rather than the colorful regalia that they were used to wearing. However, his greatest achievement was helping the Supreme Court maintain its independence, but also help it establish its authority. He had a goal of retrenchment and conciliation. He used his talent and great mind to strategically hand down court decisions that would help achieve this goal. For example, he rolled back a lot of the Federalist decisions of the Supreme Court before he was there that expanded the federal government's power. In addition, he went against tradition of inserting political statements into court decisions. Again, he did a lot to undo the expansion of the Supreme Court's power before he got there. For example, he stated that, hey, you know, this whole criminal common law thing, the Supreme Court actually has no jurisdiction over that. And in 1807, he was more specific in the limitation of the Supreme Court's powers. He stated that the jurisdiction of the courts in the United States depends exclusively on the Constitution and the laws of the United States. And he put this into action in 1812 with the court case State versus Hudson, where the court officially wrote down in their opinion that the Supreme Court does not have any jurisdiction over criminal common law. This reversed decades of Federalist claims, and it actually was more in line with public opinion. And in the case of Aaron Burr went to trial for treason, right? Because he was gathering an army to overthrow the government. John Marshall used a narrow definition of treason, which again is a departure from what Federalists had previously done. He differentiated between the conspiracy to commit treason versus actually committing treason. He said that just because you think about it and you plan to commit treason isn't the same thing as actually doing it. But of course, this frustrated Republicans, and they accused him of creating a, quote, treatise on the best way of committing treason without detection or punishment. But despite all of John Marshall's efforts to roll back the Supreme Court's and the federal government's power, he still remained a target. For example, the case of Aaron Burr actually reaffirmed in Thomas Jefferson's mind how dangerous the Supreme Court had become, especially under the leadership of John Marshall. He thought that the Supreme Court needed to be reined in and should not be as independent as it is. And now we'll see John Marshall's Supreme Court go head-to-head against Thomas Jefferson and the Republican Party. So let's quickly get the context of the Marbury versus Madison case. So remember, in the election of 1800, John Adams lost his bid for re-election. But before he officially left office, he went into a flurry of appointing judges, right? Because the Federalists had lost the majority in Congress, and they've also lost the presidency. So now the only thing they have left is the judiciary branch. So he appointed a whole bunch of new Federalist judges. And one of these Federalist judges was William Marbury. He had assigned the Federalist William Marbury with a position as being Justice of the Peace in the District of Columbia. However, things happened so fast, and this flurry of appointments, as we call his appointment of the midnight judges, there was such a rush that his Secretary of State, John Marshall then, actually failed to deliver William Marbury's commission letter. So when Thomas Jefferson entered office, he sees the commission letter on his desk, and he refuses to have his Secretary of State, James Madison at the time, to deliver it. And William Marbury knew that that letter was there, so he sued James Madison to force him to deliver it. Now, so William Marbury based his loss on the Judiciary Act of 1789. And again, remember, this was passed by the Federalists who wanted to expand federal power, and in particular, the Supreme Court's power. Well, the Judiciary Act of 1789 gave the courts power to issue something called the writ of mandamus. I hope I'm saying that correctly. But this is basically a letter that would force an official to execute a duty that they were obligated to do. In this case, right, it's giving the court power to force James Madison to deliver that letter to William Marbury. So on a side note, this actually turned out to be really awkward because it was then Secretary of State John Marshall who had failed to deliver Marbury's commission letter.
Before we dive into Marbury versus Madison, I do want to remind you that as soon as the Democratic Republicans gained control of Congress, they went ahead and repealed the Judiciary Act of 1801. This repeal effectively dissolved the newly created courts and removed the judges assigned to them, many of whom were Federalist appointees. The Federalists were outraged by this action and cried foul. They argued that this move was unconstitutional as it seemed to sidestep the established process for removing federal judges. According to the Constitution, federal judges could not be dismissed unless they were impeached and removed through a formal process. The Federalists saw the Republicans' actions as a direct assault on the judiciary, and they were pressuring Chief Justice John Marshall to respond. Knowing that a direct confrontation with Congress and the president would put the Supreme Court at a great risk, Chief Justice John Marshall actually postponed responding to this act of the Republican Congress. However, when Marbury sued Madison, he saw this as a great opportunity to respond to the Republicans repealing the Judiciary Act of 1801.
Anyway, Marbury versus Madison created a direct showdown between Thomas Jefferson and the Supreme Court. And many historians see this as actually a lose-lose case for the Supreme Court. First, if they were to pass down a decision that would be in favor of Marbury, well, they can't force Jefferson or Madison to deliver the letter, and so they would be embarrassed, right? And this would further weaken their power and authority. However, if they pass down a decision that was in favor of Jefferson, well, then the Republicans win. So it just seemed like a lose-lose situation. But don't forget, we have the genius John Marshall in charge here. So this is what he did. John Marshall said that this case raised 3 questions, and he ordered them in a very specific way. The first legal question is, did Marbury have a right to that commission letter? The second question is, did the legal system have an obligation to help him obtain that letter? And finally, the third question is, was the remedy to this violation of Marbury's right the writ of mandamus issued by the Supreme Court? So Marshall answers the first 2 questions in the affirmative. He said, yeah, Marbury had a right to this letter. It's his letter. It's a violation of his right not to deliver this letter. And 2, yes, the legal system does have an obligation to remedy this violation of his right. So the answer to those first 2 questions was kind of a slap in the face of Jefferson and accused him of violating somebody's rights. However, the key point here is John Marshall's answer to the third question. He said the way to remedy this violation of Marbury's rights is actually not in a writ of mandamus issued by the Supreme Court. And the reason why is because Section 13 of the Judiciary Act of 1789, which is what gave the court that power to issue a writ of mandamus, Section 13 of the Judiciary Act of 1789 is unconstitutional, that it goes against the Constitution. He said that what Congress did in that section of the Judiciary Act of 1789 was to alter the original powers that the Constitution had given to the Supreme Court. And therefore, this act of Congress, this act of a Federalist Congress, is unconstitutional. So see what he did there? He struck down a part of the Judiciary Act of 1789, a section that actually outright gave the Supreme Court more power, right? It gave them the power to force an official to do something. But in doing so, John Marshall laid the foundation for an even greater power for the Supreme Court. And that power is the authority to tell the people and everybody else what the Constitution means and how it should apply, and to strike down acts of Congress and of the president. So by ordering the questions in the way that he did, John Marshall actually saved the Supreme Court from embarrassment. He was able to publicly lecture and embarrass Thomas Jefferson, but at the same time, he avoided that direct confrontation and saved the dignity of the Supreme Court by saying, we actually don't have the power to make you do this. So that's the gist of Marbury versus Madison. As far as impact, immediate impact, it wasn't obvious right away how significant this case would be. I mean, today we study it in history class and it's a landmark case, but back then people just thought, great, it's not a big deal. And Thomas Jefferson continued to say that, hey, the Supreme Court is not the only authority that can tell the people what the Constitution means, right? The president and the Congress can interpret the Constitution. And the Supreme Court actually didn't use this power of judicial review again until the Dred Scott case in 1857. And again, I want to emphasize that this wasn't like a complete overnight turn where the Supreme Court just suddenly had the sole authority of judicial review and the power to interpret the Constitution, but it was very important in laying the groundwork. But again, a lot more things had to happen until then. Anyway, I hope that you have found this helpful. Please don't forget to hit like and subscribe. This will help this video reach other people who could also use it.